So, is intent required to establish a violation of an employment law in the workplace? Rich, what does it even mean? We get asked the question a lot whether an employee has to prove that an employer intentionally discriminated against them in the workplace. And the answer is, for the most part, yes. For example, in discrimination cases, we're obligated to establish as your lawyers that the employer knowingly took actions against you based upon your race, pregnancy, religion, sexual orientation, etc. That's the general rule for these cases. However, there are exceptions, and there are two main laws that we deal with: the Family Medical Leave Act, otherwise known as FMLA, and the Fair Labor Standards Act, known as the FLSA, where no intent is required to be shown to demonstrate a violation. So let me give you an example. The Family Medical Leave Act allows certain employees to take up to 12 weeks of unpaid leave for either caring for a serious health condition or the serious health condition of a spouse, parent, or child. Now, under the law, there are no magic words that are required to be uttered by the employee that triggers an employer's obligations. If the employer knows or should know that an employee has reason to qualify and need to take Family Medical Leave Act time off, then the employer has to follow a strict set of notice requirements and paperwork to give to the employee to ensure that the employee is protected under the law. Even if the employer makes an honest mistake and fails to do so, they are liable under the law and the employee is entitled to damages. So that's a situation that frequently arises where the employee notifies the employer in some way that they have to take time off. The employer fails to notify the employee of their rights, fails to allow the employee to take Family Medical Leave Act, or the employee takes time off and the employer doesn't reinstate the employer to their position. Whether they intended to violate the law or not is irrelevant. If you can establish that they didn't follow the strict procedures, they're liable and the employee is entitled to recovery. The same thing applies under the Fair Labor Standards Act, which governs overtime and minimum wage payments. So, for example, if your employer thinks they're paying you properly, but turns out they are not paying full and proper overtime or minimum wage under the law, regardless of whether they intended to violate the law or not, they are liable for damages to the employee. So we find in these areas that where there is not strict compliance by the employer of their obligations, and that's on them to figure out, not on the employee, we go after them without what we call intent violations. I know there's a little technical mumbo jumbo, but hopefully this is helpful in establishing or creating some sort of roadmap or plan for an employee who has suffered violations of these statutes. It's the week of Thanksgiving. I hope everybody's grateful for what they have in their lives. Looking forward to keeping you guys caught up on all further employment law. Be well.